Let us discuss the conflict resolution of our indigenous cultural community or indigenous peoples of the Philippines in comparison with the customary law, national laws, and international laws. The Philippines is inhabited by more than 182 ethno-linguistic groups, many of which are classified as indigenous peoples under the country's Indigenous Peoples Rights Act of 1997, or what we call as the IPRA law. And traditionally, Muslim peoples from the southernmost island group of Mindanao are usually categorized together as Moros or Moro people, whether they are classified as indigenous peoples group or not. And about 142 are classified as non-Muslim indigenous peoples groups. 142 of the Philippines indigenous peoples groups are not classified as Moro people. Some of these people groups are commonly grouped together due to their strong association with a shared geographic area, although these broad categorizations are not always welcomed by the ethnic groups themselves. So, for example, if you see people from the indigenous peoples of the Cordillera Mountain Range in northern Luzon, they're often referred to as the Igorot people, or more recently as the Cordilleran peoples. Meanwhile, the non-Moro peoples of Mindanao are collectively referred to as Lumad. The province of Bukidnon is home to 7 tribes, namely the Talaandig, Higaonun, the Bukidnons, the Umayamnon, Matigsalog, Manobo, and the Tigwahanon. Here, their tribe names are derived from the rivers or the watershed areas where they inhabit, like the Matigsalogs, for example, are the people who live along the Salog River, and the Tigwahanons are the natives who inhabit the banks of the Tigwa River. The Talaaandig people, or the Talaaandig indigenous cultural community, are the people of the slopes. These are the believers of the highest god called the Magbabaya and the spirits who guard and protect nature. The Talaaandig indigenous cultural community can be found around the slopes or the foothills of Mount Kitanglad, particularly in Bukidnon province. Now, the indigenous cultural community or cultural group of the Philippines have been given their own recognition and distinction through the IPRA law, or the Indigenous Peoples' Rights Act of 1997. In particularity to the IPRA law are chapters 3, which pertains to the rights to ancestral domains. And in their ancestral domains, section 7 says that the rights of ownership and possession of the ICCs or the IPs to their ancestral domain shall be recognized and protected, and such rights shall include section or part or paragraph H, the right to resolve conflict. So this is in relation to our discussion in ADR on conflict resolution. So to resolve land conflicts, in particularity with accordance or in accordance with the customary laws where the area was located. And of course, pertaining to other sections in the IPRA law further, we also have Chapter 4 of the IPRA law on the right to self-governance and empowerment, which Section 15 states that the justice system, the conflict resolution institutions, and the peace-building processes, the IPs here have the right to use their own commonly accepted justice systems and conflict resolution institutions, the peace-building processes or mechanisms, and other customary laws. This in particularity with their conflict resolution process in the community. And of course, it may be also compatible with the national legal system and internationally recognized human rights. Section 22 also of the IPRA law pertains to the rights during armed conflict. They have a special protection and security in periods of armed conflict, and the state shall provide or observe international standards, in particular the Fourth Geneva Convention of 1949 for the protection of the civilian populations. In circumstances of emergency and armed conflict, shall not recruit members of the ICCs and IPs against their will into the armed forces. So there is still a retention of their own indigenous identity, and they are not coerced to become members of our armed forces in terms of conflict. However, we should also not force the indigenous individuals to abandon their lands, territories, and means of subsistence, and even relocate them in special centers for military purposes under any discriminatory condition, because of course their right to a dignified living as an indigenous cultural community shall be protected by the APRA law. Interestingly, Section 62 on the resolution of conflicts under the APRA law also states that where there are adverse claims within the ancestral domains delineated in survey plans which cannot be resolved, the NCIP shall hear and decide, after notice to the proper parties, the disputes arising from the delineation. So this is particularly about the ancestral domains. And if there is a dispute between and or among the ICCs by the IPs regarding traditional boundaries of their respective ancestral domains, the customary process shall be followed. So regarding the customary process, it is first and foremost going to be used as the primary system in resolving conflicts among the IPs, and this is protected by the APRA law. 63 also pertains to applicable laws, which are the customary laws, traditions, and practices of the ICCs and the IPs of the land and where the conflict arises shall be applied first. Again, primarily the customary law. And this is with respect to their property rights, claims and ownerships, hereditary succession, and settlement of land disputes. Now, if there is ambiguity in the application and interpretation of the laws, the conflict shall be resolved in favor of the ICCs or the IPs. And also, there are remedial measures according to Section 64 of the APRA law with regard to expropriation of land, and which can also resolve conflicts in the interest of the principle of common good. And we will discuss more about the common good principle in the next slides. You must have known about the customary laws or heard about it, but what is really a customary law? Now, these are sets of customs and practices and beliefs that are accepted as obligatory rules of conduct by the indigenous cultural community or the peoples of the IP group and their local communities. These are intrinsic part of their social and economic systems and way of life and has been passed down from generation to generation. In fact, they might say that this has been their law since time immemorial. And most of the customary laws are not written down or documented, but rather passed on by word of mouth and by practice. The current Talaaandig ICC chieftain is Dato Migkitay Victorino Linsay Saway, who descended from Dato Kinulintang, the supreme chieftain of the tribe. Dato Migkitay was a prestigious leader and very known amongst the indigenous networks, the NGOs, and the government agencies, being one of the main proponents of the APRA law back in the 90s. He was also instrumental in setting up of the Talaaandig School for Living or of Living Traditions, or SLT, and he's also the father of one of our law school classmates, Insaluday Saway Sabrero. He was recently elected as the new municipal IPMR or IP mandatory representative of the municipality of Lantapan, Bukidnon in January 2022, succeeding his brother Dato Adolino Saway. The Talaaandig ICC Council of Elders, or the PASAGI, or what you call the Tribal Council, is composed of leaders of the different Talaaandig communities. There are about 10 members in all. It has the authority to settle cases, and above the Tribal Council is the Tribal Executive Committee composed of 8 members, who are the elders, all of which are chieftains in their own rights. And this is also the lawmaking body of the ICC. Overall, the Datu or the chieftain presides over the council and the executive committee and enforces the rules decided by the latter. The tribal council in turn supports the tribal chieftain. The Talaandig custom law is referred to as the Batasan and was defined by Dato Sawai as the customary practices of the group deemed obligatory and specific to behavioral practices. According to their gugud or their historical myths, the custom law originated from the conflict of two powerful deities during the time of creation, and which eventually led to the separate order of creation. Thus, natural law was established between them and became the basis of the Talaandig custom law. These laws were then dictated to their ancestors to be taught to the people and followed for generations to come. In order to learn these custom laws, the history of the tribe is related to the young people through verbal transitions or transfers of such information. And these young people are groomed to become the leaders of the community. Moreover, they are encouraged to witness different rituals and the settling of disputes. The Talandig also has its social means of preventing conflicts, such as the oral traditions and the laws and kinship. One way of preventing conflict is accounting of genealogical relationships, the education and information about the customary laws, and in particular, for example, during marriage arrangement, the bride and the groom are warned against fighting or quarreling with in-laws, and the parents of the married couple are also warned not to quarrel based on the belief that they would suffer a curse from the spirits. On the laws and kinship, these are being followed among the tribes in Mindanao to further prevent any conflict between them through the observance of the laws and kinship and brotherhood, which include the Kilalaha Batasan or the law on mutual recognition, Sayudaha Batasan or the law on sharing of information, Buligaha Batasan or the law on cooperation, and the Uyagaha Batasan or the law on mutual protection of life, and lastly, the Pabatun Batunaha Batasan or the law on mutual assistance and help. Very good example of the social means of preventing conflict is the IP Moro Kinship Day, which is being celebrated every March of each year between the indigenous peoples community, particularly the Talaandig and other surrounding IP groups around Mount Kitanglad with the Moro group of people. The settlement of conflicts through the batasan or the custom law can be categorized under two general laws, the Lagatip Habatasan and the Saungangan Habatasan. In the first general law or the Lagatip Habatasan, the payment of large amount of goods before the resolution of a conflict is made, and this law serves as the basis for settling other cases wherein the datus or the tribal council demand a specified amount of goods as payment for their services or as a means of penalty. In the Saungangan Batasan, to settle the conflicts, there is a demand of lower penalties according to the degree of batasan. And if the batasan has been violated, appropriate payment is demanded from the offerer. The process of resolving these cases are usually starting off with the dato observing the batasan. So first and foremost, there is the commission of the crime, then the dato observes the batasan. The one who committed the crime brings with him a white chicken for a ritual, that is the offering, and he gives a chicken to a dato within the council. Those to whom the chicken was given are expected to participate in the settlement and should not refuse. And henceforth, there is a conduct of the ritual proper, and the offense will then be compensated by the performance of the ritual. The conflict resolution process of the indigenous cultural community starts off with the dato and the tribal council, which the venue of which is the Hall of Peace, particularly in the Talaaandig ICC. And the goal here is to settle and conciliate both warring or opposing parties and bring back the sound relationship. The trial by ordeal, or the balaon, is a way by which the guilt of a person who has committed or been accused of committing a crime shall be made known. And an example is when a person is, or the accused is told to obtain a needle at the bottom of a container filled with boiling water. This is done to determine, again, the guilt of the person in cases of theft and murder. In cases wherein there are non-lumads opposing a lumad, if there is a robbery or land grabbing issue, it can be resolved through the help of the barangay captain following the rules of the barangay justice system for settlement of issues or disputes. The same system can also be used in the tribal community, especially when there are non-IPs involved. But in cases of robbery and land grabbing, they are also referred to the local courts. Again, the concept of justice here is for the settlement and resolution of conflicts and application of penalties. But for instance, when there is a huge issue on land and for example, encroachment and land grabbing, the NCIP can also hear and decide with regard to these land issues or disputes. And then a petition for review to the CA can also be had. This is a quick comparative recapitulation of the indigenous cultural communities' customary laws versus the national laws of the Philippines and the international laws. As a quick comparison on the characteristics of the customary law versus that of the national laws and the international laws, the governing law of the customary law is what you call the batasan, which is the customary practices of the group or the ICC. Whereas in national laws, we have RA 876 or the arbitration law, we have the RA 9285 or the ADR Act, we have the special ADR rules, and the Philippine Village Justice System. In international laws, we have various multilateral treaties such as the Hague Convention, the 1907 Hague Convention for the Pacific, settlement of disputes. You have the UN Charter, the United Nations Commission on International Trade Law, or UNCITRAL. In the symbolism of the customary law, you have the Palagusay, who is the arbitrator. He is an important figure in the community, particularly in the Talaaandig community. And in national law, you can see Lady Justice, and she is blindfolded holding a set of weighing scales and a double-edged sword in the other hand. Now, in international laws, you also have the scale of justice, which is similar to the Lady Justice, or the having weighing scales on her hand. The basis of the origins on the customary law is what you call the gugud. These are the historical myths and legends, particularly of the Talaaandig ICC. However, in national laws, the basis of the origins are the 1987 Philippine Constitution, you have the Local Government Code of 1991, and the Civil Code of the Philippines, as well as the RPC, or Revised Penal Code. For international laws, the basis here are mostly international laws and various multilateral treaties and conventions. The framework or model of the customary law is what you call the agpangan, or the patterns and models based on the environment, because they are mostly based on the belief of nature and the spirit of nature. In the national laws, the framework here were the Spanish laws, the United States Constitution and laws, and other international laws. And again, in the international laws, you have the UNCITRAL, the 1987 Hague Convention, you have the Singapore Mediation Convention, and the UN Charter. In summary, the principles of the customary law are based on, first, a common sense approach, then the principle of interconnectedness and interdependency. You also have the principle of balance and harmony between good and evil, and the equality of God's creation, and the principle of avoidance, and the principle of the wall and the shield, which we will discuss in the further slides. The national laws, we have generally the principles of justice and equities, similar with the international laws, but in relation to harmony among nations and parties. In approaching the prevention of conflict, the customary law in particular has a lot of standards in prevention of conflict, because they believe, the IPs believe, that it is better to prevent conflict than to arrive in one and then try to resolve one. So they have the pamalabag or the pamagsa rituals, they have the principle of avoidance and the principle of the wall and the shield. They have the tambudahubalagan or the peace pact traditions by the cutting of a ratan. They also have the kagsakulu or the traditional alliance. So this is with regard to different tribes, not just one particular tribe, but also with other tribes or inter-tribal connection. You also have the traditional defense system through the alimaong, the lions, and the baganis or the warriors, because these are their defense and security systems in the community. They have the food for peace, the parental leadership accountability approach, the cultural impact assessment, and the intertribal agreements or pacts. In relation to the national laws, we have the applications of the 1987 Constitution, the civil law, and the revised penal codes. We have the local government code, the ordinances, and the IRRs, and other relevant laws. Now, in international laws, we have the various international law applications, the multilateral treaties and conventions as well. The concept of justice in the customary law pertain to the gantangan or the measuring box and the timbangan or the weighing scale as determining what is just and enough. However, in national laws and international laws, it's usually sound and fair justice and equity in international law, though adding the harmony among nations and the parties. In the settlement of conflicts, the laws involved in the customary law are the lagatik habatasan, or the payment of large amount of goods before the resolution of a conflict is made. There is also a sangguangan habatasan, or the settling of conflicts but demanding lower penalties thereof, and the right to retaliate by the offended party within 8 days of the case, if it has not been endorsed yet to the dato for settlement. Then, in comparison to the national laws, you have the arbitration, mediation, conciliation, early neutral evaluation, and mini trial, as well as the barangay justice system. And in international laws, you have the negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and resorting to regional agencies. In applying the justice and in the penalties thereof, in customary law, they believe or they practice the balaon, or the trial by ordeal. For instance, the trial by hot water or ordeal by hot water, wherein a person who is said to have committed a crime and has been tried and investigated upon shall be put or to test using hot water to determine the guilt. And this is done in cases of theft and murder. Whereas in national laws, there is the application of the Constitution, the different civil and revised penal codes of the Philippines, the local government code, the ordinances, IRRs, and other relevant laws. Whereas in international laws, of course, the application of various multilateral treaties and conventions and other international laws. The preliminary authorities in the customary law of the ICCs or the IPs are the tribal council or the council of elders, together with the dato or the chieftain of the tribe. Whereas in national laws, you have the lupon tagapamayapa, the arbitrators, mediators, conciliators, the evaluators, and neutral panels. In international laws, we have the different commissions, the Conciliation Commission, UN Security Council, the UN General Assembly. We have the International Justice Commission. You have arbitrators, the mediators, and the conciliators. The highest judging authority here in the customary law of the ICCs would be the dato or the tribal chieftain. And in the national laws, you have the barangay chairman or barangay captain in the barangay justice system or the Philippine courts or arbitral tribunal. And in the international laws, you have the international ICJ or the International Courts of Justice. As previously mentioned, the Philippines is currently actively promoting arbitration as an alternative means of dispute resolution between conflicting parties. And noteworthy also that the PDRCI and PICCR, or the Conflict Resolution and Mediation Agencies in the Philippines, offer online arbitration that Filipinos can avail. And in response to the current restrictions due to the coronavirus pandemic, they are reachable through their websites and their Facebook pages. Additionally, the Philippines is keeping itself abreast with the international trend in arbitration and with the introduction of new arbitral institutions such as the PICCR, enactment of laws allowing arbitration such as the revised Corporation Code, and accession to the Singapore Convention. It is expected to become a credible and good option for arbitral proceedings soon. This has been Kathy Gabronino. Thank you for watching and have a blessed day.